I know it's a kind of a big question, but if we could just try to answer it briefly. I will start with Curtis and then Michael. How significant is the current caseload of conservation easements?
Sure. I can't give you a scientific, precise answer, but I have heard from some other practitioners around the country that the tax court's got a couple, 200 or 300 easement caseload, and that if they tried all those cases, it'd take about 3 years to get all those cases heard and tried and valuations decision. Hopefully there's going to be some kind of a settlement metric that will come into play that will allow a resolution of those cases on a much more efficient basis. The tax court, even with enhanced budget funding, doesn't really have the resources to try all that many valuation cases. Service is still attacking easements, syndicated or not, based on technicalities like not putting the adjusted basis of the property donated in the 82-83 appraisal summary. So there's things like that going on behind the scenes as well. So I think the Top Holdings case is important because it does sort of lay a metric down to at least knock out the valuation problems for something that was a quick markup case.
I want to go ahead and see if we can get another question. And Michael, we'll start with you this time, and again, as briefly as we can, to cover such a huge topic. But question coming in: what happens if there is a non-U.S. person who owns an interest in a U.S. partnership that has a CFC? Michael, do you want to start with that one there?
Sure. So in this case, you could have a partnership that owns a CFC, and there is a foreign partner. This is slightly different from the situation we talked about, but in this case, you would have a CFC because the CFC determination is going to be done at the shareholder level, which in this case is would be a U.S. partnership under these facts, and then but if there is subpart F income or guilty, even if that non-U.S. person owns more than 10%, that is not going to trigger guilty or subpart F income for that non-U.S. person simply because they own an interest in a CFC through a U.S. partnership. This would fall under the category of an item that would be separately stated and would not be taxable to the non-U.S. person.